Go forth. We're going over RICO. So some of these are just the overviews of the cases in reference to what we're reading in others. So we're at supremejustia.com. Russello versus United States, 464 U.S. 16, 1983. 1983, decided, argued. Syllabus, you got the Supreme Court, Russello versus United States, 464 U.S. 16, 1983. Syllabus, petitioner was convicted of federal district court under the Racketeering, Influence, and Corrupt Organizations chapter in the Organized Crime Control Act of 1970 of violating 18 U.S.C. 1962 C and D by being involved in an arson ring that resulted in his fraudulently receiving insurance proceeds in payment to the fire loss of a building he owned. The district court also entered a judgment of forfeiture against the petitioner for the amount of insurance proceeds pursuant 18 U.S.C. 1963 A1, which provides that the person convicted under 1962 shall forfeit to the United States any interest as acquired or maintained in violation of 1962. The Court of Appeals affirmed. Held. The insurance proceeds petitioner received as a result of his arson activity constitute an interest within meaning of 1963 A1 and thereof the subject to the forfeiture of 464 U.S. 2029. A. Section 1963 A1 does not reach only interest in a enterprise where the term interest is not specifically defined in the RICO statute. It is assumed that the legislation purpose is expressed by the terms ordinarily meaning, which comprehends all form of real personal property, including profits and proceeds. Congress apparently selects the broad term interest because it did not wish the forfeiture provisions to be limited by rigid and technical definitions drawn from other areas of law, and because the term was fully consistent with RICO statute's pattern in utilizing broad terms and concepts. Every property interest, including a right to profit or proceeds, may be described as interest in something. Before profits of a legal enterprise are divided, each participant may be said to own an interest in the ill-gotten gains after distribution. Each has a possessory interest in currency or other items so distributed. B. Had Congress intended to restrict 1963 A1 to an interest in the enterprise, it presumably would have done so expressly, as it did in 1963 A2, to construe 1963 A1 to reach only interest in an enterprise would blunt the section's effectiveness in combating illegitimate enterprise and would mean that the whole areas of organized crime activity would be placed beyond the real RICO statute. C. The fact that the Controlled Substances Act specifically authorized the forfeiture of profits obtained illegally in drug enterprise cannot be read as imposing a limitation upon 1963 A1's broader language, particularly. Page 464, U.S. 17, where U.S. RICO statute was aimed at organized crimes of economic power in all of its forms, whereas the narcotics activity prescribed by the Controlled Substances Act usually generates only monetary profits. D. Nor is a limiting construction of 1963 A1 supported by the fact that certain state racketeering statutes express provide more forfeiture of profits, money, interest, or property, or all property, real or personal, acquired, or racketeering, since those states presumably use such language as to avoid narrow interpretations of their laws, such was given in the federal statute in certain federal district court opinions. Lastly, E. The legislative history clearly demonstrates that the RICO statute was intended to provide new weapons of unprecedented scope for assault upon the organized crime and its economic roots, and thus was intended to authorize forfeiture of racketeering profits. The rule of lenity does not apply here, whereas the 1963 A1's language is clear. 681 affirmed. Blackman J. delivered on the opinion for a unanimous court. And you can continue to read the rest. Go forth. Law Dog loves you.